They're starting to put in the bulletins, like explaining more stuff from layman perspective. They put like cheat sheets, flowcharts explaining the new changes. So they started posting that. So maybe the forms are coming out soon as well. Yeah. Some of the obligations that they're now putting in on agents, brokers, like they will be, you'll be able to satisfy that using those standard forms. Let's see when they start.
How do we manage to coordinate that when you're the dressed up one, I'm casual, but so we don't actually, it's just once we want to be. Well, this is our Kormans LLP TRESA expert actually. So I do assignments, that's TRESA, so. We can make this interactive stand that people send questions through, we can stop and talk, if any of you want to raise your hands, please.
In overall, is it better for us or worse for us?
Worse.
Yeah.
I think it was a little more clarity. That's what I think. I think before the customer, I don't know what you think, Josh. I think with the customer thing, I think it was too ambiguous. Now you basically know more roles or undefined roles.
Okay.
I would say from that end of it. And just be very wary of that non-represented person. Learn to tell them the bare minimum and don't take them on. Otherwise, now you're creating a relationship that's not there. So now you have a little more caution that way.
Yeah, the mandate is to protect the consumer, like it's more for the consumer, but now you have defined rules what to follow. Like previously they weren't defined, even if you did something that you weren't supposed to do, you didn't know you weren't supposed to do that. Right now you have it defined. At least you have some guidelines to follow now. Let's get started.
That's concerns. I apologize, by the way, I was fighting with the bank on the phone. I don't know if any of you encounter this for your clients, but the bank goes, makes a payment, decides to take a second amount from the client for the same payment of towards a line or something. And so now two payments are gone and only one was applied. To fix the issue, they reversed it. So now that amount paid is gone. So now that bill is showing outstanding and the first payment, the money is gone as well. So now the bill's not paid and they're out the money. It's a brilliant strategy. Why don't you let the bill paid and just reverse the second one?
That would make too much sense.
The one thing that I always caution them is at the end of the month, please check your statements. It's amazing how many errors are made. That's 407, but as far as your line of credit payments, mortgage payments, this is why I don't like pre-authorized payments. I don't know if any of your clients when they buy real estate. I know Toronto's very popular to go and do the pre-authorized payment for the property taxes. I can't tell you how many times people have had double dipped payments taken out of their account as pre-auth from the city. And then when you go to sell the property, if you don't go cancel it, they still keep taking payments. So the property tax number, if your clients ever ask you, if they can, they should make their own payments. Don't let the city do pre-auth.
So our contact information, you already have it. We'll be sending you a PDF as well for all the materials. You'll have our contact information with you. Our areas of practice, if you don't know, we do real estate, corporate, commercial, we do wills in the States as well. Locations for our offices, we have 3 different locations, one in Mississauga, one's Bathurst, Lawrence, one Woodbine and Markham. Most of the transactions that we do, they're done almost on virtually, entirely virtual. Clients do not have to come in, but some people prefer to come in. We have offices as well. Johnson, what do you like to do?
We can't sleep at night and you want to listen to something that's not real estate related. I have a lifestyle podcast called The Chosen Life. It's on YouTube, on all podcast players. And late breaking, exciting. In 1 week's time, my book is going to be officially announced by the publisher. It goes into pre-launch. So I've written a book on health, fitness, lifestyle, making great life choices, being the best you that you can be. It's called The Bible 3.0. You check on the website, the Bible 3, the number 3.com. So it's the Bible, number 3.com. The pre-launch is announced November 23rd. You can buy it in printed book, audiobook, and printed ebook and audiobook, and it'll be in stores in January. So look out for it. And
Congratulations.
publisher's very, very excited. And apparently being number one on Amazon and things, so that's what we're working towards.
Social media handles.
Yeah, anytime you guys are on social media, feel free to take pictures of us and tag us. It's Kormans LLP, and my handle is Chosen Lawyer, and we will share your post on our stores.
So,
TRESA. Everything about TRESA.
starting with the introduction, how until now you're familiar with the word REBA. That was the legislation governing your day-to-day activities, your what you can do, what you cannot do. It's going to be replaced by TRESA. So starting December 1st, that's when the name changes. Even though some changes of TRESA were introduced earlier in October 2020, when they started to allow incorporation of breaks, and then some additional advertising terms that were allowed to be used. So that was phase one of TRESA, so of the same legislation. Phase two is where the majority of the changes are coming into effect. December 1st, 2023, in less than what, 2 weeks away now, these changes coming in. So how is the reason why they say that they're introducing it is to enhance trust in real estate, and you're going to see a lot increased obligations and a lot of increased obligations on you, the owners, to represent your client and work towards their best interest. You'll see how they're increasing that. We're going to say this a lot today, that make sure you get your instructions in writing, make sure you make all your records for your clients. If you haven't been doing that so far, start making files for your clients, separate files, start saving communications with them as you go, because you don't know when you're going to need it in the future. And you don't want to go through your phone, your emails. You don't want to go through your 100 emails to see which one's going to help you if you're in trouble. So make sure you're saving your communications, getting everything in writing. Some rules specifically say that you have to get instructions in writing. You cannot proceed without written instructions. When we go through those rules, I'm going to point that out. So make sure any conversation that having, any material conversation with your clients, you get that in writing.
So most of the cases, it's going to be a case where you have an open house or somebody contacts you cold calling, you're representing a seller, you have a listing, and person on the street, either verbally on phone, email, or in person at the open house, let's say, or if they ask to do a showing, and they're not represented by an agent. Now, this is a giant red flag for you, and you tell them the bare minimum. That's what you need to know. You're representing your seller. You are not going to say anything beyond the bare minimum without getting the advice of your seller first, their instructions, get it in writing if possible. And then you know what you're releasing or not releasing information. We all have this thing where somebody cold calls us and we're like, oh, it's a potential person that's going to help my sale go through. And you want to give them as much as possible. Now, with this whole line of client, customer, everything else, we know they're unrepresented. You're not giving them advice. You're not going above beyond telling them what the general information is about the property, and that's it, literally.
Unless they sign by representation.
We'll get into that.
We'll touch that, yeah. So starting with, we're dividing it into two parts. One, the first part will be focused on all the registrants, which includes agents, brokers, brokerages. So the first few slides will be for all registrants. Then the second part will be focused on brokerages from the brokerage perspective. Coming to first major change, no customers, only clients. So they're getting rid of the word customer. So there won't be any reference to the word customer as it was in REBA. There's either clients or self-represented parties. So a party in a trade or any individual, any entity involved in a trade, they can either be a client of a brokerage or they'll be a self-represented party. So there's no in between, which we would also use to refer them to as customers. So either they are clients, if you're providing them any kind of service, regardless of the magnitude of the service, it's whether a simple lease, a simple MLS listing, you're just listing it for them on MLS, they're still your clients. You still have all the obligations towards them. You still have to enter into a representation agreement with them. So any kind of service you provide them, you have to enter a representation agreement, regardless, as I said, the magnitude of the service.
But I think a couple things out there, your question was there, is this better or worse? I think it's better. So many people were caught in this in-between land with the customer and didn't know what to do with them, and we're treating them like a client, didn't really know what a customer was, so I think that's good from that end. Number two, I want you to think of all this from a global scale, that if anything ever does happen, regardless of how this person is identified, Where a lot of people were getting in trouble was when they're dual representing. So you double in this thing, you have a buyer and you have a seller, and they both come to the table. Either they're gonna be self-represented or you have them with another agent, not that you're involved. If something does happen and something does blow up, no matter how well you try to document it, if you double-ended the thing and you can meet both of their interests, that liability is too potentially high. From our law firm perspective, even just put this kind of on the scale of how we were doing it. So let's say one person contacts us from the brokerage and they're like, okay, I have a seller for a transaction, great, they retain us. Then all of a sudden, somebody else contacts us, oh, we have a buyer for a transaction. Turns out it's the same transaction. So we're saying, okay, Yash will represent one, Jonathan will represent the other. Issue comes up, even though we had separate lawyers, it is still the same law firm, liability is too high on the law firm. So we made a decision, we're not dual representing anymore, even though it's two different lawyers, they have to go to a separate law firm altogether. From your end, if you can have another agent in the office, it's better than trying to represent both. Eventually, I can't see a case in the future where dual representation will be allowed. But if you try double-ended thinking it's more money in your pocket, just consider the amount of liability and risk on you, and that it probably will not go well if it does fall apart. So just kind of a heads up in thinking. So I think this is the direction where it's heading in. So when you have somebody who's representing themselves, is what they're saying. They are representing themselves. That's why you're not representing them. So you're basically not telling them anything.
So this is from, you have to see this change from a perspective of a self-represented party, how they're introducing it to protect the self-represented party, so they don't rely on your knowledge. And because if they start relying on your knowledge, you'll have to provide them advice, and you won't provide them advice that's not in interest of your seller, or your client, your buyer or the seller. So that's why they're introducing this change. You have to make sure your interactions with self-represented party, you have to be cautious what interactions, what conversations you're having with them. They are allowing some kind of assistance. You can still provide assistance to a self-represented party, but that's only, it's very narrowly defined in the legislation, and it only says that which is incidental to your client's interest. And incidental means, for example, we always give this example that you're representing a seller, you do an open house, they're going to be parties coming in, they're going to be self-represented parties as well. So if they, let's say they approach you and say they want to see around the house, you can accompany them around the house. You can go with them room to room, but once they start asking you questions where they rely on your knowledge, your skill, your advice, that's where you draw the line. That's where you take a step back and tell them that's not, you can't assist them with that. Otherwise, you'll enter into multiple representation.
And think about how many questions, right, could come up. Do you think I could break this kitchen and extend this kitchen? You think I could put a swimming pool here? Why do you think the seller's selling? Are they getting divorced? What do you think this thing is going to go for? How much will they actually take? How much are comparables? Can you pull me some comparables? That question's come up on other seminars, right?
Yeah.
The issue with that is, okay, you are going to make the judgment call of what the comparables are, even you think about it. It's okay to say comparables if they tell you, I want to know every single house that's sold on this street in the last year. They give you a very defined perimeter. And you can still choose not to give it to them, saying, I'm not comfortable with it, or you have to get your seller instructions. But if they come to you and tell you, I want to know what comparables are, and you just choose to pull different segments within a neighborhood within your own defined timeline, you're not telling them what the comparables are. You're essentially giving them advice at that point. So I would pull away. Let me speak to my seller, speak to the seller. Okay, they're asking for comparables. Are you authorizing me to send them? What should I send them? Put it on your seller to see what they're, if they say, no. You know what, their seller representative, let them figure it out. They can go on an app and figure it out, because we know there's not access right to the public. They go do it on their own. But if you're doing it, be cautious. Any start information you're giving them could put your seller in jeopardy. And it seems like now you're representing the other side.
And it'll be a gray area, not a black and white. This is assistance, this is not an assistance. So the decision will be on the person on the registrant's work in that situation. So simple question, I would say, let's say, where's the kitchen? There's the kitchen. How many bedrooms? 3 bedrooms. Those are the questions you're not providing advice on. You have to make that determination whether, I would say the keyword here would be reliance. Are they relying on what you say? Are they relying on the advice or your knowledge or skill? If you're not unsure of certain things, if you think, well, should I answer this question or not? And let's say you end up answering that, good to put in a disclaimer saying that, see, don't rely on my knowledge, don't rely on my skill, don't rely on what I'm saying, get your own advice, get your legal advice, get your own agent. And you should encourage the self-represented party to get their own agent to represent them. As lawyers, we've been subject to these kinds of obligations for a long time. We have been subject to these gray areas as well. And like it's every time a client calls us, asks a question, we have to think about it. Like, should I answer that question? Should I not? That's why we are so cautious about saying anything first. We have to know all the circumstances, all the facts. That's when we answer questions.
We have a couple questions, Yash, please.
Yeah, is this better for people that are self-represented?
So as far as, I don't know, people, hopefully we don't have too many of these.
Right.
We know they're doing it because they're trying to save money at the end of the day. They think I'm not gonna have an agent, so I'm gonna get it for cheaper. Not necessarily the case with that. I know from a seller's point of view, very often, they don't want the aggravation. They just want to deal with somebody who has an agent because they're gonna be more professional about it, obviously. So I think that could be to their hindrance, actually. Not at least.
Just a situation, for example, I'm running an open house. So basically I have a listing agreement with my seller, right? And I'm asking Eric to help me during an open house, which I obviously can. Somebody comes and start asking questions. Eric didn't sign any agreement with my seller. He's just helping me. Can he potentially talk to this, answer the question and convert this potential buyer into his client?
Well, that's again, are they self-represented or not? Do they want to work with Eric and have Eric represent them as a buyer or not, or are they gonna remain self-represented? You have to have that discussion from the beginning, not act like you're the agent for them and then pull it away. At that, from Eric's point of view, first of all, he's an extension of you. So he's there on behalf of the brokerage and you, he's an extension of you at that point. Number two, once he starts having this conversation, are you representing or not? They're saying they're self-represented. He has to treat them as self-represented, period. Yeah, whether it was you or somebody called him and said, hey, not even an open house. I saw that this particular listing, oh, it turns out it's your brokerage. Can you help me with it? But I'm self-represented. He's gonna have to define that relationship. I'm acting for you as an agent or I'm not. If he's not, then he has to direct him to you and to the listing and saying, there you are as a self-represented person. There's the information of who the listing agent is, the end. Yeah, I've American review, I would just step that.
Quick question regarding commission, then what's gonna happen for the co-op commission if somebody's getting self-rep by himself? Are they gonna say like,
Yeah, I would say like situations are still present nowadays where the agreements happen privately as well. Or if there's a seller, there's a self-represented party on the other side. Usually the listing agreements would say that the listing brokerage will be paid such and such commission, and out of that they'll cover such and such commission for the co-op brokerage. But that's, if there's no co-op brokerage to be paid, that clause will never come into play, right? There's no co-op brokerage commission to be paid out
right,
if there's no agent.
so we give the commission back to the seller, basically, that portion of it?
Yes,
Or just it doesn't get billed for it.
Or we just, if some buyer comes in and it's like, you know what, I'm doing myself.
and that's usually what happens. The buyer says, I'm saving on the commission, so why not give me a lesser price?
Yeah, but if they wanna keep the price the same, but they wanna extra that 200% on the side. I think, because then
If it makes,
they can put that as their down payment, instead of putting the price, they can keep the mortgage the same amount. Take that 200% and put it back to their down payment or something
They
else.
can be paid as an agent when they're not an agent.
Right.
So they're not an agent at that
Yeah.
point. So no, I would say it's gonna be a price reduction at that point.
Okay.
Not gonna be, and that comes up quite a bit, by the way, and people not disclosing to their bank as far as rebates and all that, that can't be done. If the bank finds out about that, that's really a price reduction, so.
Right.
yeah, because if the lawyer on the file would know, they'll have to disclose that to the bank. The
Correct.
bank relies on the lawyer to make
Yeah.
sure what the actual purchase price is. So if the purchase price, they're getting some kind of credit and that to 2.5%, the bank will have to know. And if they don't tell the lawyer, they have to do a side deal.
Yeah,
They won't have any.
do not email us and say to us that there's a $10,000 amount that's been agreed to as far as reduction, but we don't want to affect the mortgage, the mortgage already been approved. They're gonna give it to them cash after closing. Can you make us a side deal? No, we're acting on the purchase, we are acting on the bank.
Yeah.
We are now represented, do our presentation. Anything we know from the purchaser's end, we have to tell the bank. Do not tell us that. As soon as you tell us that, we have to tell the bank. We have no choice. Bank finds that out and saying, hey, you're our lawyer and you did that, we're in big trouble. So no, we can't do that. So from that end of it, self-represented person bottom line, negotiate the best price they can. And using a strategy that, oh, it's less commission, so now I should pay less on the property. So that means less on the mortgage, but less on the purchase price.
Right.
Yeah, but the reasoning is, imagine you have a multiple offer situation. What are the chances with the commission and everything else that somebody with an agent is still gonna put more money in the seller's pocket? Probably pretty high.
Yeah.
So if somebody comes in and wants a deal, they really want a deal, right? So that's where you have to have this kind of discussion with your seller and saying, it's one thing if you have one offer and that's it. If you have 10 offers and 9 people are represented, one person's not represented. Who do you want to work with here? Who do you have the confidence as far as that they'll able to close? What's the situation? You know, you talk with an agent, as you tell you, oh yeah, I've worked with this person for many, many years. I know this person, but this person just came off the street. But somebody who's not represented, you don't always know what the story is. That's why you want to steer, I think, towards people working with an agent than not working with an agent.
Right.
I have a question just from your perspective as lawyers. If someone, I'm sure you guys get calls like this all the time, someone calls, is looking for advice on a specific situation. You guys ask, do you currently have a lawyer? No, I don't have a lawyer right now. I'm still thinking about who I want to use and if I need a lawyer at this time. What do you say to this person?
Also, from our end of things, so it's a question of, is it a consultation and they have a general question for us versus, okay, we need you to dig and actually give us advice on our situation. If it's something that's elaborate that, you know, we have to dig into documentation and actually provide advice, we tell them that we have not been retained yet. Here's the retainer amount, then we can open up a file, then we can review for you. If you have a general question, we can discuss in generalities, that's gonna be a very short conversation, but most people, it's not the case. They're saying, you know, I have a property, siblings on title, somebody's not talking, now somebody put a fake mortgage on there. They go into all these things, right? Like, and they send to us on our contact form and they give us the whole thing. So you see that long-winded question with many fact scenarios. Very important to step back and say, I have not been retained yet. I can only talk to you in general. If you need to go into your specific, then again, we have to set up a retainer type situation. So we try to make sure that we're not giving legal advice and reviewing stuff without being retained as lawyers. Because if we do, then even without saying it, we have been retained.
So the approach is very similar that we should be taking.
Absolutely. Absolutely.
A general questions, for example, if someone calls us and asks like, what do you think I would get charged for this transaction? My closing date is such and such. We can answer that question because that's not actually advice. When they start asking like, oh, I want to get an extension. What do you think? What the chances are? What should I do to get an extension? How to get it approved? That's when we like say that you'll have to retain us. You have to go through your situation in detail, and that's when we can answer that. If that's on email, I have a keyword saying generally speaking, and that's when I start.
My giant red flag, and this is a good tip for all of you, when somebody has contacted you through the internet, on social media or something, you don't know them, you don't know how they refer to you, and they give you this long-winded story, and they usually do it at like 2 a.m. or Friday at 6 a.m. or 6 p.m. Step back for a second, and let's think logically about this. So without even answering them, the first thing, thank you for the contact, appreciate the contact. How were you introduced to me? Let's find out where they came from. If they say, oh, my friend referred me, contact the friend, say, I really appreciate the introduction. What do you know about this person? And if they tell you, oh, this person's like a few sandwiches short of a picnic, stay away, you know this. They say, oh, it's my best friend, and you know the contact person, now you have a little bit of context to it. But anybody who generally tells you their life story on an email and doesn't even know you yet, has never made a point of contact, be very wary of this. This is probably somebody that's going to suck up a lot of your time and energy and may possibly never lead anywhere. And you'll get the same thing as agents as we get as lawyers, right? I have an issue, I bought something, now the issue has come up, can you help me? And we come back, we help you close transactions. If you have an issue that's in dispute, we'll have to refer you to a litigation lawyer. You can come the same way. If you turn out you want to sell your property or buy a property, happy to see if I can assist you. If you have a current property with an issue, I suggest you speak to a lawyer. Figure it out in that way. Don't start giving advice. very dangerous. Do not start giving legal advice. Don't give tax advice. Don't be afraid to say, I highly recommend you speak to a lawyer and or accountant, depending on your issue. In the future, if you need assistance closing a transaction, please reach out to me. That's the safest way of doing it. The most unsafe way is start giving them advice and start answering them carte blanche without knowing any circumstances. And I noticed, I've been doing this now for over 20 years. When somebody won't even tell me how they were introduced, or they say a friend of mine and they refuse to give me the name of the friend, something is fishy. It could be a spammer, it could be somebody who is legit is very happy to tell you that information. So be very cautious about this. And then it all comes back to this. Turns out that they're an unrepresented person and you went and told them a whole story about the property and about the seller, and the seller finds that out, the seller can say, you prejudiced me, and that's not fair. You weren't supposed to do that.
We have a question from Jim online.
Hey, Jonathan, Jim. How do you handle the leads that come through the lead generation program? We are not representing them, they're coming as a co-lead.
Again, I think you would treat it the same way as you would treat an open house. So you would first come back and say, thank you very much. How did you locate me? Are you a representative or not representative? Are you working currently with an agent? And then when they come back and say, I'm an unrepresented person, I'm not working with an agent, then they either have the choice to become working with an agent. So for example, if they want to work with you or another agent in the brokerage, or if you're a self-represented person, I can give you basic general information on this property, and that's it. So you'll develop, and for everybody, I highly recommend, if we do this as lawyers, you'll notice you're gonna get certain type of inquiries. So like lead generation for us, I have about 5 or 6 different responses that I use depending on the type of scenario, and I just cut and paste them all the time. Like for us, it's very often about quotes. Once I find out who they introduced us from and what their transaction is, I know based on the transaction what I'm setting out, and just have a set up answer and cut and paste it. It'll make your life easier than having to rejig it every time. And that's where you can put the little protection measures and say, I highly recommend that you speak with an agent. Otherwise, I can only give you this basic information. Do not take this as advice, and keep that email to yourself and keep cutting and pasting it to people in the lead generation.
I think you're going to see this a lot, that with representation agreements becoming mandatory, that you have to enter into representation agreement if they're your client, regardless of the service. You're going to see a lot of clients pressurizing you to go ahead and provide service without a representation agreement. A lot of people will be figuring out ways how to go about the legislation, not enter into an agreement. I would say don't give into that pressure. We get that a lot. Clients saying, oh, the other lawyers do it without the retainer. Why can't you just take a look at this and just give me an advice? You have to make sure you don't give into that pressure. You have to consider, like, is that commission worth it if you have to ever get into trouble with RICO or get into a lawsuit? Okay. So RICO information guide. So I'm sure all of you must be familiar with that form, working with a realtor. So they're changing it, replacing it with RICO information guide. So moving forward, that's the guide that you have to hand over to your clients. So every client you're entering into representation agreement with, that's the guide you have to hand them out.
And again, this is coming first week of December, not just.
Yes, it's not online yet.
It's so similar to this foreign buyer ban. We've said this in other seminars where everybody kept asking us, what's happening with the core buying ban? What's happening with the ban? Is it coming? It's not coming. We have no information. As far as we knew, it's not going to affect. And then the government drops it on us December 16th, 17th for January 1st start. And everybody's scrambling to figure out what's going on. And then by 4 or 5 months later, they started retracting and changing stuff. So as soon as those forms are available, which are going to drop on you literally last minute, you're going to expect to use them going forward. So please keep your eye out. We'll speak with the brokerage on it. And we can do another seminar once we have those forms in place, understand them. But know whatever forms they give you also, they're probably going to change it a few months later once the system comes up and says, hey, you're missing these documents, or these documents aren't working. So they're kind of using you as a guinea pig at the beginning, but expecting you to adhere to it.
I think once it becomes effective, once you start using those forms, that's when the issues will start to come up. And once RICO is informed of those issues, there will be issues that will be general for the entire industry, and I think they'll work on it. And within a few months, they'll backtrack on some of the changes, maybe provide further information on that.
But best advice is do not do the whole transaction verbally, and then as you put in the offer in or it's about to close, then get them to sign the forms. From the first conversation, you make sure that they have this form and it's clear in writing that you gave it to them. There's no doubt about it. If I was meeting with a person in person and got to sign versus doing it I would do it electronically personally. But if you're not doing it electronically, after that meeting, you email them, I confirm that here's and scan it, here's an electronic copy of the form that you signed, I confirm that I gave it to you, have some kind of record of this. When we meet our clients, we do everything virtually. We don't sign people in person unless it's an old elder person or some kind of issue. But we use a format where it's not DocuSign. It's a similar kind of idea that you're in a Zoom type room. And when we sign up the person, we send them a link to their phone or the tablet, and they're hand signing, hand initialing everything, and we record the appointment. As this gets more and more elaborate into the future, I'm telling you, a lot of brokerages, agents will start recording appointments. The appointment where they initially sign up, the paperwork with the client, and when they put the offers in. And having a recording of that conversation, going through their questions, they can't deny what you asked, never can deny what they asked, and the information that was processed. You have to understand that without a recording and without emails, everything's verbal. They can come back and say, this professional never explained to me. I didn't know what I was signing. They threw this at me and said, it's standard, just sign, sign, sign. And you'll come back and say, no, 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 I walked them through every page. I explained to them who's right now. So without an actual video recording of it, difficult. Otherwise, you have to send an email and say, I confirm our appointment where I discuss with you and literally reenact the whole thing in the email. And that's very, very painful. That's why we record our appointments. So just kind of a thought, and you can decide on your own, you know what, I'm going to do it over Zoom. Even I'm sitting with my client, I'm going to put the Zoom room right here. And if it's okay with you, we're just going to record this for your protection and mine. Just confirm what we had discussed. And some people do that. So
Do you have to ask the permission for recording?
you should be telling them that you're doing it. What we do with ours, there's a notification before the appointment starts, this is being recorded. If they don't have that notification, then you should be telling them, obviously, that you don't record them without telling them that.
Yeah.
Same thing, do not be recording telephone conversations without telling them that. I know that there's a great line on that end of it, but you're a service provider, you should always be telling them. Like the same way, you know, you're calling a bank, this call may be recorded.
Yeah.
You do the same thing. But I can tell you, seriously, we've been doing this now, we're coming to our second year.
Yeah.
Under the system. I sleep so well at night because all those hard clients that say, you didn't tell me this, you didn't tell me that, now I have a problem. I said, you know what? No problem. I'll grab the recording,
Yeah.
we can watch it together. And I know it's in my standard, so I do talk about it. They always retract. So you know what? You're right. I remember now.
Yeah.
So.
I was just going through something, and because I'm a commercial guy, I was thinking of different businesses. I think it's a great idea for the agents now to invest in body cam. Just like law enforcement doing it. We'll have a body cam right there, we can record everything.
I could tell you, and also, and it's been like, I realized this when I was in grade 10 history class. I was in summer school, grade 10 history,
Yeah.
and I had a teacher, not professor at that point, but it was a teacher. And he made sure that if he's speaking to a student after class, there was at least one or two other students, there's witnesses at all times. And I thought to myself, why is he doing this? Now I understand why.
Yeah.
And I can tell you as a lawyer, I have an appointment in person and somebody comes to my office at 5:30 and everybody's gone. I feel nervous sometimes. What if they say something? And then guess what? I have no evidence of this. I do get nervous about it, certainly. So, I mean, police have a body cam.
I know.
This isn't, I mean, this is aside this issue, but it kind of fits in if you think about it, because if somebody says you gave advice or did give advice without a recording, you won't know. On that token, it goes the other way. If I was a sub-represented person and I'm working with an agent with a body cam, I may feel a little, yeah.
It's like for mine, my work is so different, right? I mean, I have clients I haven't never met them in my life. Living up in, so Timbuktu, like I go all around and we do everything by paperwork, by open listings and everything like that. That's gonna kill us.
Use good judgment. If you're not sure, you know what, some people bring a buddy along. and to showings, you know, so people do it in teams for a reason. I mean, you can hear all sorts of stories, you know, what happens sometimes in showings and, look, the world is that kind of place. So I would say that any cancers, people, because you're an agent, people have your phone number immediately, people could be text messaging, people could locate you. Same way as us as lawyers, use good judgment. And if need be, bring somebody to the appointment if you're unsure. I've had it before, admitted in my office, I said, I need you to sit in on this appointment because I'm not sure what they're gonna say or do, and I don't want there to be any ambiguities about it, so not a bad practice.
And in addition to the RICO information guide, there's a RICO information and disclosure to self-represented party form. So every time there's a self-represented party on the other side of the trade, you have to hand out that form to them. Even if you're not representing them, you still have to give this form to the self-represented party. Plain language, clear and concise. So all the disclosure that you have to make under this legislation, any disclosure that you're required to make as a professional regulation, you have to make sure that plain language presented in a manner that brings the recipient's attention to the information that is required to convey it, which means it's highlighted, bold. You actually pointed out that this is what the disclosure is trying to convey. Must be identified by the word disclosure. So I think this is the change that will be addressed by RICO or ORIA to give you like a standard form disclosures which you can hand out. But again, the obligation of bringing it to their attention what it's trying to convey. So every time you give them a disclosure, for example, let's take an example of a multiple representation disclosure. It is disclosing it's a multiple representation. We'll go there. I think it's the next slide. We talk about multiple representation, but let's say you're giving out a disclosure, you have to make sure you highlight what that disclosure is trying to convey. That's how the obligations changed.
Can I give it to them straight now? I want you to always think of the worst case scenario of what can happen to you. We do the same thing. If something goes to court ever, first thing the judge is gonna say is big bad agent or defenseless self-represented person. You think, and when we've had people that are very well educated, doctors, engineers, and you're dealing with them, and you think to yourself, how do these people get themselves dressed in the morning? Like they don't understand the most basic thing. I've set appointments, working on a state of adjustments, buying a simple house. Okay, here's your price, minus your deposit, adjust your property tax. And they look at me so blankly. Nobody told me I'd have to adjust your property tax. Why did that happen? And so anything that happens, I want you to think you're going above and beyond, show protection for them, and you are helping them versus taking advantage of them. Because if it ever comes to it, and it just always think of this person, you'll know them, you know you're working with them, you can see it in an instant. They'll come and say, nobody explained this to me, and I got taken advantage of, they just told me to sign, and I didn't know what I was signing. And I've been to appointments and I've explained it to them and they've acknowledged to me, oh, I get that, that's fine. They email me a few hours later, like the appointment never happened. I'm like, I just spent 2 hours explaining this. It should have taken half an hour. I spent 2 hours. They acknowledged to me and now they're telling me, nobody ever explained it to me and I don't understand. That's the worst sickening feeling. We've all been there. So you have to know when you have those ones, first of all, take the extra time precaution. And if you have any kind of sense like that, immediately after the appointment, come back. It was really great being with you. We spent 2 hours. I explained to you everything. You acknowledged. We talked about the financials. Please let me know if you have any other questions. Get that in writing so they can't deny that that appointment happened and what you said. So I know it's a little self-serving, but anything like you have like that in writing, if you ever get sued, that's the first thing you ask for. What do you have evidence-wise? And that's what we do. We literally pull out for people. Here are the emails. Here's the email from November 15th, here's November 12th, here's your acknowledgement November 10th, and you reenact the whole thing from emails. And you can use text messages. We don't really advocate for it, but you can use it. But that's what you're gonna rely upon versus I went to Starbucks and I verbally told them this. So now having these forms, it's gonna make your life a lot easier because it's there, but take the extra step and document for yourself when you met with them, how long you spent with them. Again, if you can record it, fantastic, but just try to do that versus just a signature and make it go away. I even, again, if it's in writing and it's physical, a printed off copy, scan it, email it to them. Here's the copy. I gave you the one already physically. Here's the electronic one. And we confirmed all these contents. You confirmed you had it. Please let me know if you have questions. Things like that, okay?
We have 2 questions online. First one is Jim and then Sarah.
Jim, you're muted.
Jim, you're on mute.
Don't mute it.
My question was already asked earlier, Diana.
Okay, perfect. Sarah?
Hi, everyone. I just had a quick question. We do have a number of people on this meeting that work in a builder's sales office. So obviously we're representing the builder in this case, but we do have a number of scenarios where it'll be a lead that comes into the sales office from an advertisement that the builder had sent out, and B, a client who is being represented by another realtor, but that realtor is not present. So I guess my question is there anything extra that we need to know in this kind of scenario to further protect ourselves and protect the builder site?
Yeah, I would say you representing the builder won't be any different than representing any other seller. So if a self-represented party is reaching you, again, the same provisions would apply. You cannot provide advice to them unless you offer them signing a representation agreement. If they end up signing, there'll be multiple representation that is representing the builder and the buyer as well. If they have their own agent, and they have their own agent, they ask you questions, you can answer their questions. But now that you know they have an agent, you can put it into writing. If you're advising in writing, or if you're on call, you can tell them to verify it with their own agent as well. And this is what you know. This is what you have to say. But a better idea to get an advice from their agent as well.
I think actually from a builder's sales point of view, they're in the same boat. Like, literally, if I was representing now a seller on the resale, I would think, what would a sales office say for new construction and treat it the same way? They would tell you the bare minimum. They wouldn't be telling you, well, this is the profit they're making on it. I don't think they're selling very well. I think that they're stuck with X amount of, they're not gonna prejudice their seller client, right? As a builder, you would do the same thing in resale. So I think so again, they're doing it basically how they normally would do it from a new construction point of view. Now it's being absorbed into resale. That's how I would treat it. That's a good point, actually. Yeah. It's funny, out of all times we've had this, nobody's asked about new construction with the sales office, but I would just keep it the exact same way and making sure. But in any case, whether it's new construction or resale, somebody's represented, but their agent chooses not to show up, and now you're showing it for them. Got a problem here. So I would be treating them as a self-represented person at that stage, and otherwise, if they have questions, speak to your agent or have your agent contact us. A little different, they know how somebody, as soon as they know they're represented by another lawyer, and they're saying, oh, I know that you're the lawyer for the seller and I'm the buyer. Hot potato, well, okay. Get your own lawyer, I can have a conversation with you and just leave it like that, be really simple. I don't know if that kind of works. Easy.
Okay, coming to multiple representation disclosure. It was under REVA as well. You have to disclose that you are under a multiple representation, get acknowledgements from both sides that you're representing both sides. How the thing is changing here, that they're putting an obligation on you to explain to both sides that how your obligations are going to change by the fact that you're under a multiple representation. Because once you enter a multiple representation, your the service that you can provide is limited. You cannot provide advice to one client that can be detrimental to the other. That's how your obligations change when you enter into multiple representation. So that's putting an onus on you that you have to explain to both sides if you're entering into multiple representation, that how your services would change, how would they be affected. And once they acknowledge that you've explained them how they'll change, and that's when you get their consent. So you have to explain them how your services are going to change. They're introducing designated representation. We'll speak about it once we go to the next phase of the slides, which talks about introduction of designated representation, where agents of the same brokerage can represent both parties without that being considered a multiple representation. So same brokerage, different agents, if they represent either side, that won't be considered multiple representation. So your contents of your disclosure will depend on what kind of brokerage of representation model is present on that trade. But again, I think this is something you'll have standard documentation on for this disclosures as well. So material facts, there's no onus on you now when acting for a buyer. You have to take active, reasonable steps to obtain further information about material facts about a property. So they're going to be different in different situations for different properties. But the key thing here is that you have to make sure you have paper trail that you tried, you took that active steps to obtain further information. As I said, will depend on different types of properties, different types of situations, but make sure you have a paper trail, let's say a standard set of questions for the seller's agent that you sent. Even if you don't get a satisfactory answer, but if you have paper trail that you tried, you followed up twice, you were trying, you'll have that record, that evidence that you were trying, you took those reasonable steps. Because the risk here is that if you don't do that and in the future there's some defect in the property, things go to court, there's a lawsuit, and judge's going to ask why didn't the buyer's agent do such and such, why didn't they take those active reasonable steps if that was in the regulation. So good to have a standard set of questions which you fire out for all the sellers, if sellers agents, if you're acting for a buyer. Facts a seller is obligated to disclose. So there are certain facts that a seller by law is obligated to disclose to each potential buyer. For example, the most common one, hidden defects, which we also call latent defects that can make the property dangerous to live in. Latent defects are, which are not very visible. They need invasive inspection to identify them. That's one example. That's one example of what a seller is obligated to disclose under law. If, as a seller's agent, you have information of such a defect, you have to advise your seller client, and that's one change, that you have to do so in writing. You have to make sure you advise them in writing that they have to disclose it to the other side. If they instruct you to withhold the information, if they keep their position, I do not want to disclose, the legislation say you have to withdraw your representation. So if there's a defect that makes the property, let's say, dangerous to live in, you have to encourage your client that they should disclose to the other side. If they don't, you have to withdraw.
If your client seller comes to you and says, okay, I never told you this, don't worry about it. You know what you need to do at that point. If you say to them, okay, that's fine, don't worry about it. And then it comes out that you were aware of it, you disclose it, you're in big trouble. So the second you catch wind of it, you either have to do the right thing or walk away. But you can't tell your seller, okay, I'll work around this with you. No gray areas.
Practically speaking, I think effect of this change would be that there will be more disclosures moving forward, because agents are going to err on the side of the caution. And if there's any defect that they come to know, they're going to encourage their seller clients to disclose. Otherwise, the seller's in trouble, seller's agents in trouble. I think practical effect of this would be more disclosures.
I will guarantee you that any of your sellers do that, if it comes to when they get sued, they will throw you under the bus 1,000%. Will you look at a judge and say, I didn't know, or you say, well, they told me not to say anything, so I figured it's okay, you know, that's your judgment call. So I'm telling you, from many clients that have seen through this and realtors, you just rather not have the sale at all than have a lawsuit. You just don't want to go through that. You'd happily give the money to make it all go away. So make a decision at that point, tell them to do the right thing, or you're not going to be able to represent them and walk away from it.
We had a question.
Sorry, just a simple scenario. For example, I signed an agreement with the seller, and in a few days he calls me, oh my God, I found some mold in the attic, for example. But they'll take care of it. I know he's hiring a company, the company fixed it, everything is good. By the time, for example, I'm getting an offer, do I need to disclose that, let's say, mold was found, but it was fixed? Or because it was fixed before the offer, I don't have to, like.
Interesting, because the guys have come up quite a bit, and especially the ones where the offer's already been put in and they went and fixed it. So you have to read the representation and warranty very clearly in the agreement. If some are more encompassing as far as any issues with property, including mold, if they put that in there, then you have to disclose. If there was an issue beforehand, but it's been fixed, there's remediation. Most people don't disclose that, but it has to be fully done and confirmed. But the danger they have with that, and we've seen this one, is that there is an issue that comes up after closing. They said it was fixed, they even got a certificate, the buyer goes and gets a rechecked. Turns out there is an issue, and the company tells them, well, that's interesting because I was here fixing this 3 months ago. Now you got a big problem. So they got to be very cautious with that. Like, if they're gonna fix it, it better be fixed, it better be 100% certified and no issues from there. But if there's any chance at all that there's going to be an issue after closing, better course, disclose it.
I'll answer that with a very similar situation that I had recently. So we are representing, our clients were doing 4 transactions. So they were selling, the 2 sisters selling, using the money. So one of the sisters was buying 1 property, the other one was buying 2 properties, 4 transactions in total. That sale money was to be used in 3 other transactions. 2 days before closing, I get an email, like a big email from one of the sisters saying that, oh, I went to the house, the bulb wasn't working. So I went, I got a new bulb. I replaced it, but I noticed it's still not working. So I call an electrician. An electrician comes in and sees the unit, the entire unit has the wrong wiring that's not allowed under the building code and needs to be changed. So that, like, the ceiling needs to be brought down, the wiring changed, the ceiling brought back. They got a quote of like $75,000. And that's 2 days before closing. And I got that in an email, like a long email explaining everything. And they had an electrician report saying that what the situation is. I felt like leaving my desk and running away. It's like 3 other transactions. And now when they disclose it, the other side's going to freak out. My option at the time was only to let them know that they have to disclose, like, now they have knowledge of it, they should proceed and disclose it. If they don't disclose it, they run a risk of getting into a lawsuit, getting sued later. That's what they did. We disclosed it. There was a lot of back and forth. We went on. At the end, they closed the transaction, even though they still might be a lawsuit later on. But that's the situation. But as now you as agents, because you have an obligation to disclose yourself. We as lawyers, we don't have an obligation. If they instructed me not to disclose, I wouldn't have disclosed it. But now you as agents, if you know of such a situation, not what I'm saying about the wrong wiring, but something that they are legally obligated to disclose, you have to tell them. And if they don't comply, you have to back out. One of the most exciting changes, I would say, a heavily discussed topic, sharing contents of competing offers. Most of us are referring it to as an open offer process, but that's not what it is. It's not a purely open offer process. An open offer process would be every potential buyer would know all the contents of the other potential buyers, but that's not how it's going to work. What they're doing is they're simply removing the restriction on the seller and their agent to disclose the contents of a buyer's offer to other buyers. So that restrictions is not there. A seller is not obligated to disclose the contents. So the seller will make a decision what will be disclosed and what will not be disclosed. So a seller can make a decision that the entire contents of the offers are disclosed. They can make a decision part contents are disclosed. They can make a decision nothing is disclosed. So
All up to the seller.
yeah, all up to the seller. So if a seller says, I only want the purchase price and the offers to be disclosed, so that's what the agent's going to disclose to the other potential buyers. If they say just the closing date, that's what gets disclosed. So, and another fun thing, they can change that at any point of time. So a seller at the offset can say, I want only purchase price to be disclosed. Then they say, oh, not the purchase price. I want it to be, I want that not to be disclosed, and now I want the closing date to be disclosed. And then you have to comply with that direction.
But look, a lot of us, we know the situation, right? A lot of our clients just rely on us to say, what would you do? What do you think? What's the best course for me? And you gotta weigh it out with them. You gotta say, look, if I was a buyer on the other end and the seller is monkeying around and giving me only a couple pieces of information, I might get very frustrated with it. So you need to make sure they see the shoe on the other foot kind of thing, and ultimately think what is going to put them in the best position. Most say, you know what, we're going to be very open with it. 3 offers, here are the prices, here are the closing dates, two are unconditional, one has one condition. Put it flat out. Is that the best way to work? A lot of people would say yes, some people would say no. So you need to work it out, but be careful about this slippery slope, because then they're gonna come back and say, my agent, my advisor, my professional told me I should only disclose this and this. When really it was their idea and you didn't really stop them, so be careful, please.
So we can just get them sign a form, just like, you know, you just, Mr. Seller told me not to advise. But, you know, content of the offers, blah, blah, and that's it, done, we'll protect our rights.
And you're not sending them the dining room, so instead of doing a phone call, just jump on Zoom, hit record, have a conversation with them.
And that's
Eric does not look at the news. But you know, this is all political and this is all for showing that they're protecting the public, right? That's what everything is at, that's what loss.
At some point, you wanna tell them, you know, maybe you should disclose because then you'll get a higher price than what you expect. You wanna, because you're acting in the better of your client, right? But then it's like coming from you and then they can play with it. So it's like kind of.
Exactly, and I know we're all gonna get caught in that, so they do something with us as lawyers and like, okay, what do you think we should do? And we tell them, that's a business decision. We cannot make the business decision for you. All we can tell you is the options. You need to make that decision. Don't be afraid to do the same thing with them. Tell them, listen, I've laid out the options for you. Ultimately, this is your decision. I can make that decision. And if you have to, you're not sure, not feeling good about it, email that to them. Put it in writing.
The seller instructs me that he wants to disclose a price. Let's say I have three offers. Am I allowed to say our maximum price is 1.4, or I have now to disclose offer number one is, we received the price is 1.2, offer number two, 1.3, and offer number three, 1.4.
What is your seller instructing you? If your seller tells you,
Disclose the price, I have to disclose all three offers.
if the seller is instructing you, you follow your seller's instructions. You
Or
can't-
seller can tell me just disclose the maximum price, like the best offer. It's also possible.
Your seller can say, listen, you're gonna tell them there's three offers and you're gonna tell them, that the highest of one and not say which one it is. They can go all sorts of routes like that, but again, from the buyer's point of view, they're probably not gonna be very impressed with that and that's the information they're being disclosed, right?
Exactly.
But theoretically, you could. I mean, the only, we've talked about this, right, you and I, the only way to have full disclosure is wipe out the person's name and send everybody copies of all the offers, then you'll know exactly what's there, otherwise you'll never know for certain. And, from what I've seen, I haven't had to ask the question yet, but usually they're not disclosing at all, or they are disclosing, there's none of this in the middle stuff.
Yeah, but then the 1.4, let's say the highest offer can say, am I crazy? I'm paying 200 more, right? Thousand, I'm stepping back, like it's.
Yeah.
A very dangerous situation.
Yeah, it can fire back to the seller. So that's why you need to explain yourself that it can fire back as well. So you have to seller will have to make that decision whether to disclose or not. If they want, like, if they don't want to take that risk, they can keep it confidential. They don't have to disclose.
What was the point behind this rule? Would they want a transparency? What's behind this?
It's I mean, again, it's the whole political game. It's showing the public, we're showing transparency, but when you see the actual rules, there may not be transparency. So that's it's for show, right? Like we all expected to be full transparency then, but that's probably where it's gonna be headed. But they didn't feel comfortable yet doing that, so they're putting it on the sellers and their agents. Yeah.
Yeah, like
Yeah.
they always do.
Yeah.
So one thing to keep in mind is that if you're acting for the sellers, you can't disclose personal identifiers of potential buyers. Like if in an offer, their names, their phone numbers, or their email addresses for notices, that's the personal information cannot be disclosed to the potential buyers. Right, accessing real estate. So moving forward, real estate can be accessed only if a registrant is present, which is not very different from now how it is nowadays. But now they are allowing people to access real estate without a registrant being present, as long as the seller client consents, right? So if you're acting for a seller and a self-represented party, or maybe like a represented party as well, whose agent's not available for showing, and they want to access real estate, and let's say you're not available at that time, the seller, if they are okay with the buyer or the potential buyer coming in, you have to get the written instructions that they consent, and the other party will be able to access real estate. And now you must be thinking, what about?
Again, a self-represented party coming into your client's property without somebody present.
Now, you must be thinking insurances, whose insurance covers damage, if there's damage, homeowner's insurance, there's no registrant, so whose insurance would cover it? Right, so this is something that your seller client should be made aware of. When we were discussing this with some other brokers, some agents were like, we're gonna make it our policy. I mean, we're gonna advise our clients straight ahead, don't go with it, don't allow it.
So just to clarify, a client, I have an agent, and I want to go look at a property on Friday. My agent's unavailable. I can call the listing brokerage's office and make an appointment for myself.
This is the case of self-represented we're talking about. So if they are represented, they do have an agent. Different, I would say, different scenarios. They'd be getting another agent in the office coming with
I
them.
would say that still the buyer's agent would coordinate with the other agent, but if both the agents are not present to be there, then like the listing agent would have to give you consent that you can come in without your agent.
But if I was a buyer agent and I can't make it, I would be wary of having my client going in completely alone there as well, because something happens, it could fall back to me. Yeah. So even if they do allow it, I don't think I would allow it if I was the buyer agent. I would either go myself or send somebody else from my office. I would not send them out on their own.
I think you'll still need the buyer's agent to book an appointment, but if the buyer's agent is not available and the seller's agent is not also available to be at the property and a represented party wants to access as well, looking at it from the seller's agent point of view, they can provide consent, but they need the seller's written instructions before they do that.
So when we take listings, most likely there will be another form. The seller will be giving us instructions on this specific situation.
Maybe they might be informed for this as well.
They may not be.
Yeah, they may not.
We don't even grasp what forms they're doing it.
Yeah.
If I'm the listing agent, the buyer's agent calls me that I can't be there, but can you make arrangements for my clients to see the property? In that case, nothing is falling on me, right? Because I'm just asking the seller and one of the buyer's agent is requesting this. Are you okay with this? If seller says I'm okay, then it is represented by someone else.
You better get your client's instructions very clear. You understand this person is coming in on their own, no agent. I'm comfortable with that. Make that very clear to them.
This is the name of the agent, this is the brokerage, he's from, and his client is coming, all that information.
Again, think of the worst case scenario. Your client calls you up, 12 hours later, my Rolex is missing and my Versace jackets are missing. How did you let me do this? Well, you gave me okay, you said it was fine. But when you give them, when you get their instructions, it's not just getting instructions, you have to give them the scenarios. You have to tell them, okay, are you okay with this person coming alone, or would you feel more comfortable if they came with an agent? You understand that they're not there. I don't know what they're doing in there. So,
Or maybe better you be there to show them the property, right?
well, unless you're showing the property, you open the door and you're there present, but somebody is there.
One thing to consider is like if the other agent's not a company and you are being present, so do you want to be the only person there with a professional liability insurance if something goes south? Like if you're acting for it, you might want to encourage the buyer's agent to be there.
What I'd be doing as a lawyer, I'd be investing my client. I gave you the options. I told you, I don't think it's a very good idea. You gave me the instructions, okay. I confirmed that despite my advice, you gave me the okay to authorize some representative person to come into your house.
Then we are scaring him, so obviously he will say no.
And you would say, we're not so scared. Why are they doing this? Because if we get sued, you have to show that we did that. And we rolled back and said, new instruction, it's okay. That writing means nothing now. They'll say, you didn't give me the options. You didn't tell me that this was a bad idea.
We have a question online, Gagan.
Yes, so in case of condos, like a security guard can show the unit then? If I'm having a listing in a condo and the seller can, self-represented buyer wants to see the unit.
And most condos that I know of, they will not agree to do that. The most they're going to do is show you where the lockbox is.
Mhm.
And the security does not like to even go up and open the door for you. So very difficult, and they definitely won't stay around and watch as the person goes through the unit. So I wouldn't be relying on condo management for that. Again, that, most cases, you're gonna have the lockbox. You're gonna send where the lockbox code is, and they'll direct them where the lockbox is. That's it.
Okay, because
Be careful of that.
Okay, because I have one listing in Touchstone Resort in Muskoka, and the reception at the hotel reception shows the unit. Like they have, because it's in a rental pool.
It's a resort, they're involved with it. It's
So
a little
the
different, right?
seller
Yeah.
actually, seller gave us the instruction to show it that way, and we got it in the listing. So it's similar idea, right? With the buyers can go and see it.
Exactly.
Yeah, only the freehold properties will be a hard, because somebody's personal house, how can we show it?
But even in most condos, you're gonna be in the same scenario. If any of us deal with a condo, let's say downtown Toronto on Yonge Street, anywhere. Generally, you're giving them a code, they're gonna get their own key from the lockbox, the security lets them in to the elevator, they're going up the elevator by themselves, they're unlocking it by themselves, and they have to put the key back in the lockbox. Right, how many of you have been in a scenario where the key from the lockbox went missing because somebody forgot to put it back in the lockbox and put it in their pocket, right? I've had a couple of those and people freak out, so.
Okay.
I would say with condo, you could have even more issues with it potentially.
Okay. Thank you.
Okay. Yeah, we're not meaning to scare everybody and tell them don't do this, but we also want you to have your alerts up at all times and just, it's better for you at the end of the day. If you could sleep at night better that you're following certain protocols, less likely for issues, that's all. Because you know people are gonna try to take advantage regardless.
We have another question online, Rosanna.
Hi, just a quick question. With all these changes, what about leases? Has anything changed or no?
Yes, because as I was mentioning, regardless of what kind of services you're providing, you'll still have to enter into a representation agreement with them. So we've had this question before as well, because with leases, people reaching out to you, you were treating them as customers most of the time. So now the customer word not being there, no provision for customers, they'll be considered your clients as well. So again, for leases, if you're providing service, providing advice, you'll have to enter into a representation agreement with them.
Mm-hmm. Okay, thank you.
Yeah, now we will see how it's practically going to work moving forward. But that's what is it for now, that you have to enter a representation agreement before you provide any kind of service.
We're doing business as usual, right? But we just have to be extra cautionary,
Yeah, pretty much.
extra careful.
And look, in most cases, it's you represent one party, the other party has their own agent, the end. It's again, this gray area where there were customers, not customers, and now they're actually formally allowing self-represented people. But generally, all of us as professionals are very nervous about self-represented people because then they're gonna come back and say, you did advise them.
Oh, sorry, yeah. So request for information by RICO. So this is a clause giving part to RICO that they can request information from all the registrants for any trade that they worked on, any file that they worked on, basically reserving the right, putting in the legislation, they also want to keep methods to them in order to enforce it. So that's the clause that gives them the power to enforce it. RICO can ask you for information, ask brokerages for information, and you have to comply with it.
Is everybody here electronic wise part of the paperwork goes? Good. Because I know some agents, they still use paper copies for whatever reason, and they have all these banker boxes full of files. And, oh, is it old enough? Can I shred it? Just be electronic, please. Get everything virtually signed, electronic. Save all your PDFs in your cabinet. If you comes asking for paperwork, we could find it in 2 seconds. Not if you're going rummaging in your basement and looking for paperwork. It shouldn't be at that point anymore. And we never know when they're gonna come for it, so just, you have it electronic, you have it forever.
New code of ethics, there's a new updated code of ethics for registrants. We've included a link here for you to access. So that's the text. Most of the changes are, some of the changes are transferred from REBA to TRESA, some with some amendments, some without the amendments, just the way they've been. just listing the ones that have been updated, conflicts of interest. So if there's any conflict of interest in a trade or with your client, you have to disclose it to them. You have to get their acknowledgement and consent that you can proceed with conflict of interest. You have to take steps to avoid conflict of interest and obtain, again, the written consent to proceed if there's a conflict. Yes, these regulations were still present under REBA. You still had to disclose. It's just that some updates, confidentiality, you cannot, confidentiality is a key.
Continues even after the relationship ends. So a year after the transaction's over, you're sitting with somebody at a cafe, don't talk about your clients. Never talk about your clients. I wouldn't even acknowledge that I work with them. Like as lawyers, we can't.
Yeah.
So you come to me and you ask me, I heard you work for so-and-so. I'd say, I don't know, go ask so-and-so. It's always say less. It's much easier. Don't ever put yourself in a conflict position like that. You disclose somebody's confidential information and it's found out, it's very bad.
With commercial world, we use other names to get access to next one, right? I mean, I work with this guy, I work with that guy, I do this, I do some lentils for him.
But there's different levels of it. So for example, there's certain things that are public information. This was the company and I acted on the sale of this property and this was the owner of the property, the corporation, that's one thing. To start having their personal information, so that person is the president of the company and they themselves are getting divorced, things like that.
Right.
Things that are public information is very easy, yes, by all means, but only the bare minimum. Yeah, just be cautious. Yeah.
I recently had a call from a fire insurance adjuster. There was an old client of ours. He house got fired, and the adjuster called me and they were like, "We're not able to locate the client, and can you give us some information about what's his address, what's his phone number?" I said, "See, I cannot do that. Even if I want to try to help, I won't be able to do it." I said, "You'll have to maybe ask the other side if they are okay to."
That's a really good one. Like you could be, okay, I know, I saw advertised on the sign, you represent so-and-so on a transaction. I'm a whole buddy of his. Can you give me his info? Don't give his info, contact your client and say, so-and-so is asking for your email. Can I give that? Or do you want to contact them directly? But yeah, that's again, that can go to fine line. Even disclosing somebody's cell phone when it's not public information and giving that out, people get quite upset about that.
I gave you a few months ago, I was in Italy, I got a call from a fire marshal in Windsor. They're like outside, they have my boards out there, right? I mean, they just call me up.
Yeah.
I mean, there's a fire violation in the property, they gotta get in, they need to talk to the landlord. He was in Hawaii, I was in Italy. How do I do?
Okay, so I can tell you as a lawyer, I'm messaging that person directly. Fire marshal is outside your house. Here's the person's information. Please contact them immediately.
Right, yeah, that's what I did because I had no way to get a hold of him. He was on a cruise, right? So, but situation like that, like it need to be addressed right away kind of thing, right? I mean,
they're gonna reach them the same way you would. Theoretically, right? And if they can't reach them, you can't reach them.
Right.
Yeah, so, no, understood from the emergency standpoint, but even still, and I've been in that position almost identically. I reach out to the client directly. Somebody's outside your house, they need to get in ASAP. Because on the same token of it, I'm not there. They could be, so-and-so's in the hospital, has been in a car accident, I need them immediately. People will pull all sorts of scams to get that information out of you.
Yeah.
Be cautious. I've had somebody claim to be from a bank institution and need the person's information. I said, give me your contact information and I'll get my office to see if this is applicable or not. And then I reach out to the client. This person from the bank is looking for you. Don't know if that's real or not. You can reach them back.
Consider a question like this. Like this was a multiplex with 20 units, right? I mean, it was self-managed by my client, but there's a property manager involved. I mean, obviously, property manager is not my client. I mean, I can share the information very quickly for quicker access. Or client never did.
I mean, look. Most places when there's a multi-unit res, there's a sign outside the door or outside the property managed by a property manager. That should be, fairly easy to find out that information. So
right.
I don't see why you wouldn't disclose that.
Right.
Yeah. If in doubt, contact your client, ask them, If the reach out to the person directly. Yeah, yeah.
Right, no obstruction of legislation. We usually see it on other legislation as well. You cannot do anything that would obstruct RICO's powers to exercise their legislation. You have to comply with them if they ask you for information. A lot of political stuff, I would say, that they want to show they have power. Discipline committee has some additional powers now. They can apply conditions to a registration. They can suspend the registration. They can revoke a registration if registrar is found not complying with the act. So any misconduct before December 1st, 2023 will be decided under REBA. So any misconduct, any circumstances that happen after December 1st will be under the new legislations. There'll be a license appeal tribunal as well, where if you think, if the registrar thinks the decision was not correct, the decision of the discipline committee, they can appeal it to license appeal tribunal. Right, key changes for brokerages. We're done with the part where it was for all agents, all registrants. Now we come to just the brokerages. I think we don't have slide for that, but because it was changed, it was introduced after all of the changes, the thing, designated representation. So I think maybe you had your meeting from the brokerage perspective, maybe you discussed it at that meeting. But now moving forward, the brokerages will have two representation models. One will be brokerage representation, one will be designated representation. So until now, we are familiar with the brokerage representation. Client relationship was at brokerage level. Client representation was at brokerage level only. So same brokerage, different agents representing different sides. That's considered a multiple representation at today's on today's date. But moving forward, brokerage will have an option to adopt designated representation, which means agents will be designated one agent will be designated representative of one side and the other agent will be designated to the other. So that won't lead to a multiple representation situation between the agents. So you don't have to limit your services as if they were done in multiple representation. So you won't enter into multiple representation in this situation. So seeing it from a brokerage perspective, the brokerage, even if different agents and it's a designated representation model, the brokerage still has to remain neutral. So let's say one agent reaches out to the broker of record asking for advice. That broker of record cannot advise that agent, which is detrimental to the other agent's trust or other parties' in trust. Brokerage still has to remain neutral, so has to make sure that they consider it as a multiple representation.
Back in the days, we had multiple offers come in, you're doubling a deal, which is, I do all the time, so that you get a broker record to send your first offer in, right? I mean, your own offer, and then you do with other offers that coming in from the other agents. Brokerage looks at it and then makes it, sends to the first offer to the seller, and then can be the same practice, could be done same way right now if you don't like it. For example, it's a way like, sometimes, you have agents you don't want to pay, right? You don't want to pay another agent. Part of it. It happens all the time in our industry. We don't like to pay kind of pie. So sometimes, yes, we involve broker record to sort of, minimize that fact. But now the thing, we can't even touch the client anymore or the individual as a customer, right?
But in most cases, again, the smartest thing to do is not to be multi-dual representation scenario where you actually put buyer and seller. One agent in the office is acting for one is acting for the other, and actually keep that line, keep that wall up. That's what we were doing as a law firm until we made the decision that we're not going to represent both, because saying that the brokerage has to be neutral and with the law firm, it's inviting too many issues. Again, it's if you have everything in the house and an issue does come up and now they're in a conflict position, how are you able to represent both adequately? That's going to be the question.
So this is going to come to my scenario, my part of the business. Like, for example, I work with a lot of open listings, kind of like the seller's not ready to sign until we bring an offer in. And the offer comes in, if the seller signs, and customer service with us pretty good with the offer. So what's gonna happen now? I mean, I have the contact with the seller already. In person, I know all the information about it. I take that in. I go to my investors, I pitch it to investors. They put an offer together. I bring it to the buyer, sorry, to the seller. And then that seller signs the offer, signs me a commission agreement and a seller customer rep or agreement that time.
So no more customer, number one.
Yeah,
And then number two, you're working with the seller, but you're not signing paperwork with them unless an offer comes in. You're starting to get into mucky waters there because you're not working with them essentially,
Right.
and then they're not getting information. And then only when the offer comes in, then all of a sudden you're gonna sign the agreement with them. I would try to avoid those type of scenarios. I would still try to lock in that seller, being clear it's for their protection as well as yours.
okay.
Because you're not giving them any of the paperwork, and they're not familiar with their rights, et cetera. I'd be very cautious about having that kind of scenario. What do you think, Yash?
Yes, of course, because when we discussed representation agreements, it's based, as soon as you enter into a client relationship, you have to make sure they sign that representation agreement. The legislature say that even if you don't sign a representation agreement, something goes wrong, they can still consider it as an implied representation for it.
Except they haven't gotten any of the paperwork from you yet. So with this kind of scenario coming up, I would insist on them getting the booklet, them acknowledging it and acknowledging the relationship.
Can the seller be a self-represented seller from the very beginning? If I get that kind of form to sign, it's like, you're presenting yourself. But I'm bringing the buyer in.
But then you're acting for the buyer. Right?
I'm working, obviously,
It's
I'm working for the buyer.
You're talking about a private sale now, essentially. Like somebody puts for sale outside their front lawn.
Yeah,
I don't want agents and all that. You can bring a buyer, right?
right.
And you have to be clear that you're representing the buyer, and then are they gonna pay a commission or not?
Yeah.
Then
But I'm getting all the rental out of the seller. I'm meeting the seller, I'm getting the rental, getting the leases. I'm putting a package together and giving to my buyer. So is that?
Right, you're putting an offer together with your buyer, you're handing it to the self-represented seller, the seller's gonna go take it to the lawyer, or they're gonna be taking it to.
Right,
But it's very clear that you're not representing the seller at that point. That's essentially a private sale.
yeah.
Yeah.
So the same thing we were doing was it before, or now?
That'd be very similar. It's again, making sure the paperwork, if there's gonna be a commission structure or not.
Oh, yeah,
I mean, there's some structures where the buyer's gonna pay you, but that's very rare. Usually you wanna,
not anymore.
but if they're selling it by sale by owner, they generally don't wanna pay commission. That's why they're selling by owner, right?
That part, we always work it out. We like, at your prices, we add our portion on top and we bring it to the buyer as a package, right? But my question is like, where a lot of my transaction that happens, our seller always been present themselves, like they don't want to pay, go to open market, or they have a physical sign, they're like talking about retail plaza, for example, like, move them a lot, right? And then they give me a rental, they give me all the leases, they give me the tax papers, right? And then I take that in from the seller and then I give it to my buyer and then buyer puts an offer together based on that. So in a way, I'm actually getting introduced to the seller in the beginning, but not as an agent, because back then again, I'm using customer service form. But now I can get them signed a self-presenting form right now and, take that package and give it to my.
It's this kind of forms, I can't see why you can't have a self-represented seller at that point.
Right.
Then be very cautious of what you've done at seller if you're acting for the buyer.
Yeah.
Yeah.
Oh, yeah.
You're just having the reverse, basically.
Yeah, so that's exactly what the seller wants. They don't want to, too many agents involved. They don't want to, things to be, publicized so much in the market that,
Again, it's a self-represented seller. I'd be cautious about the commission and how you're gonna work that out. And if you have some sort of paperwork for the commission side of things, are you actually representing that seller at that point? Because
First
what paperwork you're using.
first deposit goes right to the brokerage. That's how I'm not protect myself. Whatever deposit is good, cover my commission first. But is there going to be any issues in that?
We'll know better when we have the actual forms.
Okay.
Yeah, everything that we've seen materialized is on a self-represented buyer. There's no issue why you can't have a self-represented seller, right? But again, just be cautious that most don't want to pay commission, and if you do, what paperwork you get them signed for the commission.
So if you're considering them self-represented party for time being that you're bringing in a buyer.
Yeah.
And you sign a representation agreement, once you have a firm an agreement, they can still be considered your clients since the start of things goes down.
No, but the seller's never going to sign. Seller never going to be my customer.
But it's still going to pay you commission.
It's still going to be my
And there's no
commission.
trust in this customer.
Yeah, I'm sorry. Don't worry about it. So like because there was a form in RICO that we used to get them signed. The offer, like, you know, you're doing customer service and you're paying me commission based on this buyer, this right there, with this brokerage name, and I'm representing this buyer, and, you know, this much commission gonna for this particular property, and if the offer doesn't work, there's no agreement between us.
Yeah, now the customer agreements are getting rid of that. Maybe we'll see different forms.
Yeah.
Or maybe they're gonna even like just straight ahead, not allow commission on that. We're gonna see once the forms come in.
Okay.
And there's no stopping from a scenario where you're acting for the buyer. So you agree on the price for the buyer and the buyer understands that the buyer is actually paying your commission. There is scenarios where buyer does pay their agent the commission. And that makes sense because the seller's not paying it. The seller wants to sell the property privately and they don't want to deal with agents. So you may have to make a side deal with your buyer and say, look, I'm getting to you this price. You're the one who's gonna pay me. So instead of the seller paying me, you're gonna have to.
Yeah, for this market, never got, even last 5-6 years, I've probably done it 2 years in the last 16 years in the business.
Right.
This buyer paid me because of too much of a steal of a deal for the buying this land, right?
Yeah.
And, but, I mean, and again, we used a lot of times, our own homemade forms. Or-
Very careful.
Or, I mean, that was back in the days. Like, you know, get the seller to sign it for my commission, right? I mean, and then seller paid on
So
that.
let's wait and see what the forms come out and then see about this self-represented seller and if they do deal with it or not.
Okay,
Yeah, good question.
that's pretty much gonna shut me down, basically, my business, that doesn't exist.
Or you just evolve it a little bit. You may have to make more scenarios where the buyer pays you, that's all. You can explain to the buyer, look, it's either the seller's paying it out of it or you are, it's the same calculation, just how you explain to them.
Right.
So the multiple representation is one thing, you know, where he's the designated, for example, he's the designated agent for buyer and I am the designated agent for the seller. But the dual deals, like double end deals, they're still allowed, right? I'm having an open house, I have a buyer who is very serious about buying unrepresented buyer. And he wants to use me as his agent as well.
You can still go ahead.
Yeah,
Multiple representatives still allowed, but again, your disclosure requirements and how you have to limit your services. That will still be up.
So those kind of double end deals are still allowed.
They're still allowed. Again, as Johnson was mentioning, it's risky going into, like, it was risky under REBA as well. It's just more risky now because you have so much disclosure requirements.
Yeah, and I think from the brokerage point of view, it's brokerages having their policy set out as well. It's really,
Yeah.
because again, I can see foresee some brokerages won't allow it, they're saying that's our policy, we don't have it. I haven't seen that yet. But regardless, make sure the brokerage knows, make sure both sides know, make sure you get your paperwork and going down the line.
In certain situations, you know, we use.
I don't know a lot of agents are double ending anymore. They bring another agent in from the office and each one works. That's how I've seen it. I don't see many.
That's how we used to do,
Yeah.
like, we have to be creative, you know. or-
Yeah.
Or it's the friend realtor in some other brokerage.
Somebody, but having your name on both sides of it, very risky.
Unclaimed trust funds, so brokerages will have to submit unclaimed, it was 1 year until now, they'll have to submit unclaimed trust funds if they're unclaimed for a period of 2 years or more. That's when the unclaimed trust fund have to be submitted to RICO.
They still come up there, Let me see if that's where most people grab.
Most people probably.
Okay.
Lawyers and accountants can sometimes take little.
Our accounting department hates us. We have money from like 5 years ago and it's on a tax holdback or something along the line and they can't figure it out and we don't have the authorization and otherwise you need a court order. It's very, very messy. Otherwise, I've had one where I had to apply to the law society and get the law society to take over the monies and I had to show all the communication, trying to locate the person. It's a nightmare with trust monies. It's terrible.
Notification to RICO, so brokerages have to notify RICO immediately if these facts apply. So brokerage's liabilities exceed the realizable value of their assets. Basically, if they're in insolvency proceeding, if it's commenced against them or receipt of knowledge that such an insolvency proceeding is imminent, they have to notify RICO. Court order or judgment, anything related to trading in real estate or breach of trust or misappropriation, that's when they have to notify RICO immediately. Shortfall in missing property. So if there's a shortfall in brokerage's trust fund, they have to notify RICO immediately. Missing property, if any property was held in trust for a client that's missing, that has to be notified to DECO immediately as well. Additional records, that's a catch-all phrase, basically telling brokerages make additional records. The most try as best as possible to make additional records for all trades, all clients. That's a catch-all phrase, putting in an onus on the brokerages. Try your best to keep additional records for all your trades. Impact on registrants' day-to-day activities. So changes that we discussed today, they are the major changes that are going to affect your day-to-day activities the most. There are additional changes as well, but I think most of them will be addressed in the standard forms that come out. The disclosure requirements, getting instructions, I think there will be forms for that as well. At least now you have an idea of what to look out for on the changes that we discussed. Nice, thank you.
Thank you, guys.
Thank you. I know that it's somewhat clear and has layers of confusion a bit. Again, forms come out in December, we'll see what's involved. We can come back and talk about those issues as well. Basically, this is always, again, it's bluntly, they gotta show that they're doing stuff and accept it for what it is.
So far, they're touching based on the most of the buyer side, like how to protect the buyers and kind of nothing with the sellers. Like, for example, listing presentation is somewhere in a listing presentation, right? I mean, still they're not your client nor your customer listing.
Well, they are protecting the seller in the sense that you can't have information from the seller's point of view disclosed unless the seller gave instructions. So
Right.
that's a heavy seller protection measure. Yeah.
Does anyone online have any questions?
We'll have you back if you have any other questions or just general legal stuff. We're here, so just say hello. To help and thank you for having us. And as transactions come up, you need assistance with closings. I have questions, please reach out to us anytime.
Thank you. And everyone online, we will circulate a copy of this video of today's session as well as the slide deck as well.
I will send it. Yeah.
Bye-bye, everyone online.
Thank you. Bye-bye.
Thank
Bye.
you.
Thank you. Bye.
Here without Jim in person.